Good evening. Welcome to The Big Fight. I'm Vishnu Shom. Bilkis Bano has said that she was bereft of words and numb after 11 men who raped her during the 2002 Gujarat riots were set free. I trusted the highest courts. I trusted the system. I was learning slowly to live with my trauma, she said. On the 15th of August, all the 11 convicts sentenced to life imprisonment walked out of Godhra sub-jail after the BJP government in Gujarat allowed their release under its remission policy. 7 members of Bilkis Bano's family, including her toddler daughter, were murdered. The woman, who was 5 months pregnant, was then gang raped. We're looking at the outrage which follows the Bilkis Bano case and the remission of 11 men. As I introduce my panelists, just in terms of how we structure it, we give them a minute each to make what we call the first punch, where they make their primary argument before we move on. Joining us, Vrinda Grover, Ashutosh the columnist, Alok Vats of the BJP, Deshratan Nigam, Zainab Sikandar and Aman Lekhi. I'd like to thank you all very much for being with us. Vrinda Grover, in 1 minute, your first comments. Can you go ahead, ma'am? Your time starts now.
The remission of the 11 convicts who were convicted for gang rapes and mass murder. 14 persons were killed. It was a targeted hate crime. The reason why it is arbitrary, discriminatory, and therefore an unlawful exercise of executive discretion exercised by the state of Gujarat in consultation with the central government is because this is one of the most heinous crimes which can be committed. The law says the first question to be asked at the time of early release, even after 14 years, is whether the offense is an individual act of crime that does not affect society.
Yes.
Answer to that is, it is not an individual crime.
Okay.
It affects not just Bilkis Bano. It affects all of society.
All right, all of society. Vrinda Grover, I'm interrupting because your first minute is over. Ashutosh, go ahead. Your 1 minute time starts now.
See, I will not get into the legal and the technical aspect of the whole matter. I see an entire pattern in this. And this remission is not a simple case. If you look at the Maya Kodnani, she was convicted by the local court. High Court acquitted her. But SIT till now has not challenged that order. Babu Bajrangi, he got 14 temporary bails from the court, and by now I'm talking about he's out of the jail, though he's convicted. In Kathua, who were the people who were supporting rapists, everybody knows. Who was the minister who had gone to Jharkhand to garland those who got bail and who were accused of and convicted for the life imprisonment in what case?
Sure.
So there is a whole pattern here. So for me, it's not a legal issue. It's an issue of a political party.
All right, it's the issue of a political party. It's not just a legal issue. Ashutosh making that point. Deshratan Nigam, your turn, sir. 1 minute, your first punch. Go ahead.
Vishnu, personally speaking, whether the people who burnt alive the 59 car sevaks in Godhra should never be released, nor the heinous crime that we are discussing today should never be released. However, it is not a personal opinion that matters. It is the legal framework under which the executive, the judiciary and the legislature or the common citizens have to work. So government had the power. Whether that discretion which has been exercised is arbitrary or not, nobody on this panel can say, because one has to look at the conduct of each of the individuals who applied for it. And that has to come from the jail record, what kind of service they rendered inside, and so many other factors. So to that extent, the legal laws and legal framework and the guidelines available and the directions of the Supreme Court will prevail. We may have a personal opinion on this subject, but the rule of law says that we have to be governed by the existing law and not otherwise.
All right, be governed by the existing law and not otherwise. Zainab Sikandar, go ahead, ma'am. Your first comments.
First of all, my first question to everyone who's watching the show is, how are we even viewing Bilkis Bano? Are we viewing her as an Indian? Are we viewing her as a Gujarati? Are we viewing her as a woman? Or are we viewing her as a Muslim? Because depending on how you view her, you will form your judgment on what's happened on 15th August when we were celebrating 75 years of India's independence. The problem is, here in this case, this was a very long road for justice for Bilkis Bano, which in 2008 she got from a special CBI court where the 11 convicted were accused. Then in 2017, the Bombay High Court upheld that conviction, but now it's all been undone. So it looks like a story of brutality to a woman who feels unsafe and traumatized. My question is, when the additional Chief Secretary Home of Gujarat says that we have left these 11 based on age, nature of crime and behavior in prison, why aren't we also seeing the ages of Bilkis Bano when
Why
she
aren't
was
they
just
also
21?
seeing the age of Bilkis Bano? All right. Aman Lekhi, you've got 1 minute before we start the big fight. Go ahead, sir.
Well, Vishnu, according to me, this has to be seen from two angles, procedural and substantive. The question is whether there was a right, one, and the issue is whether the consideration of the right was appropriate. Now, two things what you have to actually keep in mind is that when the sentence was imposed, the sentence was not of life without remission, it was life simpliciter. And because life simpliciter in that event, after 14 years of actual imprisonment, an entitlement to invoke 432 comes, which is actually affirmed by the Supreme Court in May. Now, the Supreme Court not only affirms that right, but also specifies the appropriate government, the state of Gujarat. So, therefore, the entitlement to approach the state of Gujarat. When the remission is filed, however, there are certain parameters which have to be considered for deciding whether remission should be granted. And of them, is the nature of the offence is one aspect of which all of us know, the gravity of the offence, and related aspects are the potentiality to commit the crime, the need to continue the conviction, and of course the socio-economic condition of the person concerned. It's the balance of all these factors which must be considered for the purpose of deciding whether remission should be granted or not, and that deals with the substantive aspect of due process. What is peculiar about this case is that there are 11 individuals.
All right,
and I do not know
there
the
are
order
11
because
individuals.
the
Interrupting
rules would be
you only
distinct.
because your first minute is up. Apologies for that. We'll come back to you later on this program. But I want to start up this debate by going first to Vrinda Grover. Ma'am, do you believe that this is a political conspiracy, that this could never have happened had there been, a fair, transparent political setup in Gujarat?
It's not a political conspiracy. It's abuse of political executive power. Brazen, blatant, and not only the state of Gujarat. This is a CBI investigated case. Let's be clear on the law, since people seem to think that legality will save them here. The central government had to have been consulted as per law. The central government has agreed to this release. This is called abuse of executive discretion. This is what it is. This is a carceral state that we have today, which is giving long, hard sentences, death penalty for all forms of rape, etc. And the same governments, the same Union Home Ministry thinks it fit that 11 people who have committed gang rapes and mass murders should be released. This is by the advisory committee, which had 2 BJP MLAs as per media reports, one of whom has only a short while ago given an interview saying these men were Brahmins. The convicts, we are talking of mass murderers and gang rapes. These men were Brahmins, they must have had good sanskars. That was one of the criteria on which they were released. Is this Article 14 violation? Is this Article 15 violation? Prohibition of discrimination, equal treatment before the law. What is the government telling us? What is the state telling us? The law cannot save this kind of absolute gross abuse of executive power.
All right. I want to get Deshratan Nigam to respond to that. Abuse of political executive power in this case. Is that what happened, Deshratan Nigam?
I have not seen any law on the subject where it says that the power granted under section 432, 433 CRPC, where the word appropriate government has been used, who has the power to remission, should consult the central government. Nor there is any judgment.
Please see section 435.
Please,
no,
I've
sir,
seen.
You are a man of law. Please see section 435.
Don't interfere.
Don't mislead public. I think lawyers should stop misleading the public. Read section 435.
Please
read section 435.
Please don't. You had your time. You had your time. Please, you had your time.
Why can't
allow
you
me
read
to
section
finish.
435?
Please,
Why
you
do you
read it
want
when
to
your term
mislead
comes.
people?
You read it
Well,
out.
surely
read
you
it
don't
out
have
when
a,
your
have
term
a leg
comes.
to stand on if you're
Vishnu,
going
I
to
don't
falsify
debate
the
like
law.
that. Vishnu, I don't debate like that. I don't
You-
No,
debate
but
like
you are
that.
telling wrong
Deshratan
law.
why don't you respond to what she's saying? Because she
That's-
says you're
allow me to-
referring to a
allow me to-
go ahead, yes.
Read
Allow me
section
to complete
435.
first.
Vrinda, half a
How
second.
can it be so hard to read it?
Allow me to complete first because I never interject.
Go ahead,
No,
Deshratan
I
Nigam.
don't tell the wrong law. That
This is
the
the basic
distinction
courtesy.
between you and
That's
me.
a basic courtesy of debate. That's a
No,
basic.
the
You get your
basic
time.
courtesy is truth. The basic courtesy is truth. Do not waver from the truth. Read section 435 Code of Criminal Procedure.
All right, Deshratan
Madam,
Nigam, respond.
Madam, I have seen your truth of political, reaction as a lawyer. You went into politics.
Don't make personal. Don't get personal. Stay with the law. Stay with the law.
Let us be on the subject. Let us be on the subject. I saw your opinion, initial opinion, very political, not legal opinion. Okay, anyway. Therefore, the Supreme Court directed the appropriate government in this case is the Gujarat government, which has taken decision under 432 and 433. One. And secondly, let me also tell you, the legal framework as it exists, the 1992 policy, which was prevalent in 2002 when the crime was committed. Therefore, that policy was applied, not 2014, and Justice Nandrajog also did not find any fault with it in his interview. So the issue which arises today, whether the law needs to be changed or not, we are debating so that the rule of law as it exists has to be applied. If it has to be changed, it has to come from the appropriate legislatures. And therefore here, whether it has been applied arbitrarily or not, none on this panel can say this because they have not seen those 11 individual files where the report from the prisons must have been asked.
11
And
people all together all became good people.
see, you have to see the file. You can't presume. Neither I can as a
No,
lawyer.
but sir,
presume.
I mean, it seems, let me bring in somebody else. Zainab Sikandar, is this something that you accept that all of a sudden 11 people all together at the same time became okay and all went through remission?
I will tell Deshratan Nikamji one thing which the CBI had noted. Do you know the 7 bodies of the people who were killed in this case were exhumed by the CBI and none of them had their heads. Their heads were severed. Why? Because their identity shouldn't be found out. This is truly a diabolical case and you're telling me 11 people who were so diabolical have been made an exception because they have suddenly changed in behavior. So look, I don't want to get into the legality because I'm not a legal expert. But I'm truly telling you, does your conscience allow you to justify the most unjustifiable case? This was a case of utter grotesque nature of these 11 people who thought it befitting to smash a 3-year-old Saleha's head on the ground, who thought it okay to gang rape a woman who's 5 months pregnant along with gang raping her mother and 2 sisters. If anybody can justify this on the panel, then I think we should all remain silent because we all have collectively lost our conscience. What we are trying to say, if you are saying that these 11 people suddenly became the creatures of God, what was happening in 2002 was the creatures of Satan. They committed the most heinous crime and we can't expect that correctional because law says that these people have to be reformed and then accordingly judged. We can't be sitting here saying that the government of Gujarat has decided that suddenly these 11 people have changed and their hearts have changed and their souls have changed. And I would like to also point out one very important thing. The Gujarat High Court very clearly said when this remission was being discussed, they had said this remission should not be decided by anyone in Gujarat because anyway this case had been transferred to Maharashtra. So they said it should be the Maharashtra government who should decide this. But then the Supreme Court said, okay, no, let the Gujarat government decide this. And another thing I'd like to point out, which Yaqub Rasool, the husband of Bilkis Bano had said, that they still don't have a permanent address. Why? Because they are so scared. You think they are not scared today? 11 men who have been welcomed by an organization with garlands and sweets.
All right, in fact, that is a part which is so deeply offensive. Aman Lekhi, I wanted to bring you in on this. The manner of their release, the fact that they were seen with garlands, the fact that they were seen with mithai, what does this actually indicate that they were allowed out in this manner? It's almost a celebration which took place. What does this say about us?
Well, the manner manner in which they were actually received is inappropriate, because it's not as if they're coming victorious. They're actually convicted for a crime which they did not challenge, because the matter rested the Bombay High Court, didn't come to the Supreme Court. But there are a few issues which I want to in any case highlight. Firstly and correctly, as far as 435 is concerned, it's relevant because it does contemplate consultation. But that is one aspect of the issue, that is this appropriate government has to consult with the central government. That said, reliance on the MHA guidelines, in my opinion, not appropriate. Justice Dhanraj Jog dealt with it because Article 20 will come in firstly, and the MHA guidelines are not necessarily under 432. Thirdly, more importantly, I don't think either political considerations nor an eye for an eye or Hammurabi code will be relevant over here. And mainly because an offence is Gori doesn't necessarily mean a remission will not be granted, because remission can be granted even in death sentences. That said, the nature of the crime is a factor which has to be factored, and that will bring in the element of substantive due process that I mentioned in the beginning. And in this context, we have to see the order as to how it distinguishes between the role of the 11. Because if the role is of the 11, the circumstances will be peculiar to each, and in deciding whether remission is to be granted at all or not, there has to be an individual application of mind, keeping the parameters, and not just the Gori nature of the offence is a very important circumstance, but other aspects. Whether that has been done at all or not is moot, and that will be actually decisive for us to conclude whether this particular remission is right or not. Many of the panelists, of course, the nature of the offence is such that the outrage is understandable. But the point is, none of us actually know this particular what the particular order is, unless the order has actually examined the issue, keeping in view the circumstances which law considers appropriate. Whether we call it political consideration or we call it eye for an eye, reformation is irrelevant. It will be judged only on the law. And I personally feel that unless it satisfies the requirement of law, it cannot be upheld.
It cannot be upheld unless it satisfies that this. So do you believe that it can be challenged? Very briefly, Mr. Lekhi.
Absolutely. This is not, no decision of the government is final. It is subject to judicial review. The courts are the custodian of our rights. And so far as the final word on what the law is and what the law permits lies with the court. So the court will have the final authority.
All right, the court will have the final authority.
As also
sure. Ashutosh, is it not strange that there are any number of people for far lesser crimes in jail who will be languishing for years, but in this particular case, individuals with some of the worst offences were released?
See, Vishnu, I guess in this case, we tend to forget that the entire system wanted these accused not to be punished at the first instance. If you look at the case, when the case was in the beginning, this case was closed by the police. This case was closed by the police. Then the case had to be shifted from Gujarat to Maharashtra, and only then these people were punished with life imprisonment. And now you see what happened. So the same system is fighting back again. The system which did not want these to be punished, they wanted Bilkis Bano to suffer all through, and there was no remorse in that system. And it is because, that's why I'm saying it's a much bigger crisis. It's basically a byproduct of the majoritarian politics. It's a perversity of a very highest order, that where in Maya Kodnani case, the local court punishes her with a convict her with 28 years. High Court acquits her, but SIT till this date has not found any reason to challenge in Supreme Court. What does it speak? It speaks that the same system is working over there, which doesn't want the riot accused to be punished. And why so? Unless there is a reason, and the reason is the majoritarian politics.
All right,
the same system which works in Kathua, where it works in Kathua. You remember very well, the rapists were applauded by a political party. They were on the street, and they saw to it that the girl who was raped belonged to a particular religion should not get justice.
Right. Alok Vats, there is a system at work over here which was determined to ensure the release of these men. That's what Ashutosh says. How would you respond?
See, everything that has been done on the Supreme Court direction. They directed the Gujarat government to consider...
Sir, do you think the Supreme Court was... Do you believe that this order was correct, sir? Do you believe the release of these men was acceptable?
See, under the expression of regret and reform, you can...
No, I'm asking you, Mr. Vats. We know the legal issue. We know what the Supreme Court said. I am asking you, do you believe the release of these men was correct?
Frankly speaking, on humanitarian grounds, they have suffered a lot. They have been in jail for 15 years. And they
Sir,
have
did I
been
just
sentenced.
right? Vrinda
But they have
Grover, would you
suffered
like
a
to
lot.
respond to that?
I think this is the political party which demands capital punishment for any rape accused. Same political party. But if accused,
Mr. Vats, one second, Ashutosh. One second,
religion,
Ashutosh, hold on. Vrinda, hold on. Mr. Vats, did you just say that these people have suffered and they should be released? Did I hear that right?
You see, if the court has taken the
No, forget the court, sir. We know what the court has done.
under
You
the
just
remission
said on
policy.
this program, Mr. Vats, that these people have suffered a lot. They need to be out. Did I hear you right?
Yeah,
One
can
second,
I
Vrinda.
can I just 1 minute? This is not a judicial order. The Supreme Court has not asked them to be let free after 14 years. Yes, 15 years is a long time. I actually am not a votary for long incarceration. I oppose death penalty in every case, including the gang rapists who were hung when many people, even including here, were supporting it, including the central government.
Mr. Vats, is it the position of the BJP that it is
Just a
okay
minute.
for
Can I
these
just
men to
finish,
have been
Vishnu?
released?
Half a second.
Let me tell you
Is
one
there
thing.
a state
Earlier,
policy of reformation? Are
Madam,
we,
please allow
is
me
the
to
state,
speak.
is the central government, is the state of Gujarat engaged in a policy of reformative justice?
No,
Are
Vrinda,
this
Vrinda,
working
one
as
second.
correctional
Vrinda,
force?
half a second. I
If
really
that
need
is
to ask.
not happening,
No, one
then
second. Vrinda,
why
I need to
this
ask
is an
Alok Vats this
exception?
question because I want to understand what you're saying. Mr. Vats, you said that it is okay that these men got out after 15 years. Is that the belief of the BJP as well?
Well, if it is under the law and the JSC has found that they should be, it had 8 members. And so they all
Things
unanimously
can be under the
decided-
law, but you are free to disagree politely. I am asking you, is it the view of the BJP that there is justice in the release of these men, considering what took place? Yes or no, sir?
Personally speaking, no.
Right.
But
And what about the
officially,
BJP, sir? What about the BJP?
BJP has to go by the law. Yet we cannot.
No,
outrun the law.
certainly the BJP has to go by the law. Everybody has to go by the law.
Some
You are a
of them have
BJP
been
leader.
released.
I am asking
Some
you,
of them-
as a journalist,
some of
the
them have
position
been
of the
released on
BJP.
medical grounds.
Does the
Some of
BJP,
them-
no, it's not medical ground. We are not talking about medical grounds. Does the BJP believe that the release of these men was correct? I'm not asking you to say whether you accept the law. The law has done what
Not
it has
only-
to.
not
This
only
panel has
these
done what it
11.
has had to say. I'm asking you
Please
if the
let me
BJP
correct the
believes
fact.
it was
Not
correct.
only
Yes or no,
11
sir?
Not only 11 people, but 26 prisoners across the state were released on this remission ground.
And you
Just
believe
not
that's okay,
11.
sir? Do you believe that the rapists should have been given remission?
I am not with the rapist. I am not with anybody who is murdering. But yes, there has to be a remorse and regret also.
Alok
And they
ji-
have been there since last 15 years.
Alok
So
ji, can
if they
you-
move the plea,
Can you say these are the people with good moral conduct? Can you say on this channel
Not-
that these people have a good moral conduct? They should be
obviously not.
and they should be
Obviously
released.
not. If they had a good moral conduct,
So why
they
are you
would have
justifying
done
them?
this sort of thing.
What
Aman
what-
Lekhi, you've got your hand on your
There's
head and I
always
know
a
you want to
chance
make a
for
point.
reformation.
Mr. Lekhi,
Be a
There's
man.
always a chance for
Are we
reformation.
unable to, on this program, understand the difference between right and wrong? Do we only say, but the judges have said this or a panel has said this and therefore we go by that? As educated people, should we not be looking at the larger picture?
Larger picture, they should
One
have
second,
done
Mr.
that.
Lekhi. Mr. Lekhi, go ahead.
On a question of principle, I'm very against either bringing political consideration or religion into a debate. This is purely a legal issue. We have to examine it. I don't share the views that because it's a Muslim, this is so a majority. It's a result of majoritarian mindset. I don't think these muddy the waters. The issue is straightforward. The question is capable of an easy answer. The question here is whether the grant remission is substantively correct. One of the factors is the period of 15 years, but that's not the only factor. You have to balance that particular factor with the nature of the crime and also take into account circumstances peculiar to the individual. The only point which you have to see here is not whether one is a Hindu, the other is a Muslim, because this debate somehow every point of time gets corrupted with this particular thing and that creates a division. Law doesn't recognize these particular differences. The law's vision is absolutely clear, and that's what I'm saying over here. The question here is very simple. Is substantive due process satisfied? For that, you have to look at the provision and you have to look at the Constitution. And all you have to see it, examine the matter on merits to say whether the legal principles stand satisfied. And it seems to me that because this is a decision dealing with 11, not dealing with the differences in the 11, and therefore the circumstances peculiar to each of the 11, to give all 11 together the benefit may make it infirm, but it's actually infirm as to await looking at the order.
Sure.
So rather than having a priori opinion, and insofar as saying that yes, this is so, we have to actually examine it, and yes, prima facie, there is something which requires us to consider it, and this is a matter which does require scrutiny, whether the remission is right or not. But to make the issue larger and say it's majoritarian, it's Hindu, it's Muslim, I think it's wholly unnecessary.
I take
totally
that point, but the question I was asking Mr. Vats Amanleki was, does he believe this is correct or not? Right? And he seemed to suggest that people can reform themselves. But then that seems to go against the principle of what the centre itself has said on Azadi Ka Amrit Mahotsav, when they said that, look, in cases like this, there should be no remission.
Vishnu, I personally feel whether he thinks it's right or wrong is irrelevant. Question is, does the law recognize it to be so? We are not going to look at what a person subjectively feels. Our opinions count for nothing. That's the reason why.
Our opinions count for something, sir. This is not a court of law. Oh, yes, we are judging the law, but this is not a court of law. If we give up our humanity, Mr. Lekhi, if we try and couch everything on a humanitarian issue through a legal prism, I'm sure the judgment is fine. Perhaps it is.
Can I intervene?
But Mr. Lekhi, there is a larger injustice over here. By saying that maybe these people,
absolutely, the law,
all required remission, we are forgetting the larger issue. Can't we just say that no, this is a crime? This woman had a baby killed in front of her. There were 7 people murdered over here. She was gang raped by 11 people. Where does the question of this arise? It's wrong.
Vishnu, that is exactly the point. That is exactly the point I'm making. First of all, law and humanity are not necessarily divorced. And in fact, law is necessary to be humane, to be just. No question. That's the reason why law and equity go hand in hand. That is not an issue, and that's the reason why you have discretion in law. Otherwise, the dead letter of law would rule. I'm not in any way disputing it. What I'm saying is that the question you put, what another person may think to be right or wrong, is not decisive. Yes, the gravity of the crime is very material circumstance. But the question is, remission is available for the most heinous of offences. The question is, you will not look at the offence for the purpose of deciding if remission is right or wrong, whether the circumstances relevant to remission are made out. Okay. In this particular case, the way in which it has been exercised makes it suspect. That's what I'm saying.
Okay.
But whether it is actually so, that's the way
he makes an important point. If I understand it correctly, that without knowing the merits of each and every case, and every person granted remission would have a separate order, none of us are in a position to actually decide if it's right or wrong. Is that something you accept?
Those papers can't be in the public domain, and therefore it's very important that it is subject to judicial review. Who will go? Will the state go? The very same state? Bilkis Bano has spoken.
But shouldn't this be in the public? From a legal standpoint, Vrinda, shouldn't this be out in the public? Is an order of a state board?
So let
why is that confidential?
And the central government satisfy all the citizens that justice is being done without any discrimination. Everyone is equal in the eyes of law. The burden is on the state government of Gujarat and the central government, the Union Home Ministry. Put these documents in the public domain and tell us that our criticism is wrong. Do not put the burden of judicial review on Bilkis. She is tired. The legal system and justice system has left her hopeless now. The burden is on the state.
Okay. Zainab Sikandar Kabin, you had a point to make. Go ahead.
Yeah, I agree with Vrindaji. Does the state government, if they have been so kind to these 11 convicts, will they be kind enough to Bilkis Bano and provide her security? Because you tell me, if an organization is garlanding these 11 convicts, how do we know that there will not be any security threat to this lady who's fought so long for justice? In fact, the government of Gujarat had just given her a 5 lakh compensation compared to the trauma she endured. It was the Supreme Court who actually served justice right. And I'd like to make a small point. Just on 3rd August, a man in Jabalpur district in MP was released on bail. He was also a rapist. And he went back. He was in jail for 2 years. He was given bail. He went back and raped the woman again on night point, gang raped her with his friend, and took a video of it and told the woman to take her case back. These kind of examples are also in front of us. So who assures security of a woman? And the bail was given under law.
There's a larger issue as well. Deshratan Nigam, do you not believe that the Prime Minister, the Home Minister or somebody senior at the centre should be addressing this?
See, the fact is, Prime Minister is quite clear, and he did make a point from the ramparts of the Lal Killa. And those points are very clear, but these are guidelines. States, you cannot impose your will on a state.
On the same day that the Prime Minister, Deshratan made that remark, these people were released. Is that not a double standard?
See, I cannot go into the political aspect of it because the timing, whether when a matter is ripe for signing, a lot of work has already gone. Maybe the file was put on that day and it was signed in a routine manner because it was already complete. The process was already completed. A 2-month process was already there. But as I said, in heinous crimes, the law as of now allows it. But should we be discussing the change in the law?
No.
So that is the larger issue.
The law does not have to change. The law does not have to change. Again, you mislead on law. So sad. Very tragic. Misleading on law over and over again.
But Mr. Deshratan Nigam, why don't we let... I understand that you want to say... Vrinda, half a second. Vrindaji repeatedly says that on a matter of law, you are misquoting and misleading. So why don't you respond to that?
I'll admit to the extent that 435 does allow consultation with the center. I stand corrected to that extent.
Consultation does not allow, it mandates consultation. Please
that's
read
what I'm
the
saying.
law. It's not allows. It says it's compulsory.
See, the fact is, I have said,
the Home Minister
law allows.
Before 15th August 2022, the Home Ministry would have been consulted.
Hold your horses. I
don't have any horses. The horse is bolted from the stable. That is the
whatever it is. Vishnu, this is the first time.
Go ahead, Deshratan-ji. Go ahead, respond.
This is. I never debate like that. Please remember, unless until you allow me.
All right, Vrinda, let's allow him to speak. Vrinda-ji, please, let's allow him to speak. Go ahead, Deshratan Nigam.
See, the fact is, I completely agree with Aman Lekhi. As long as there is a system or rules available and laws which allows it, they have to work within that framework. That is what the rule is. Whether the consultation with the central government has taken place or not, I am sure they must have. Otherwise, this is an anomaly. One. Secondly, let me also tell you one thing. Without looking, as I think everybody should agree on the individual cases, individual files, about what kind of a conduct they had inside the prisons. Because I know certain convicts who had been given life imprisonment and death penalty, which was later remission was done. They did humongous service, legal aid they were doing. There were lawyers who were convicted. They were doing legal aid. They were working inside the system. So they were considered for parole and remissions also. So these are the factors already available. Yes, we should discuss about the change in law, whether such kinds of remissions should be brought, exceptions should be brought under the CRPC or not under 432 and 433.
All right, Deshratan-ji, 1 second. Vrinda, you had a point to make. Go ahead.
Yes. Half a minute, half a second.
Vishnu, half a minute.
Ashutosh, 1 second. Vrinda first, then Ashutosh.
Just a minute. Remission must be allowed, parole must be allowed, early release must be allowed. All principles which exist in the law in 1992 continue to exist today. I am not arguing against them. The reformation must be encouraged and the state must release. I am arguing against what the state is doing. The state is not treating its citizens, including its incarcerated citizens, with an equal hand. Some are being released in an arbitrary and discriminatory fashion. There is no debate required on change in law. The law does not say you have to release every person after 14 years in jail. Are you saying that in state of Gujarat prison today, there is no person inside who has completed 14 years? This is an exercise by a committee in which there are 2 BJP MLAs. So to say that it has nothing to do with politics is equally fallacious and facetious, so let's not go down that route either. This is an abuse of power. The abuse of power cannot be curtailed by changing law. The abuse of power has to be introspected by those in power and has to be stopped. by judicial review.
Okay, all right.
Can I give me 10 seconds? Give me 10 seconds.
I'm running.
Just give me 10 seconds. Just give me 10 seconds.
Vishnu,
Just give
One
me
second,
10
let
seconds.
Ashutosh reply and then I'll come back to you if I can. Ashutosh,
Vishnu,
yeah, he was waiting.
this is not a case of law. My dear friend Desh Ratan, do not understand the law is available, but this was the human element in the implementation of law which was available. And these people who decided that they should get the remission should have thought in their conscience that whether they are doing the right thing or the wrong thing. They collectively decided, unanimously decided, and the two BJP MLAs were present in that meeting. So they could have gone against, they could not have given the remission, but they had given. That is why I am saying there is nothing wrong with the law. The problem is who is implementing that law.
All right.
Why the conscience of those people who unanimously decided to release them did not bite them.
All right,
Who
Desh
are
Ratan
these
ji,
people? Where
you literally have 30 seconds. Go ahead, Mr. Nigam, you are right to respond. Yes.
See, the fact is, if you read 432, 433, there is also a process given for consultation with the court which has convicted them. It is may, the word has been used may. Whether it has been done or not, it has to be seen in the file because the court's opinion is also taken here. And secondly, it's a discretionary power subject to judicial review. Thirdly, it can be brought in public domain under the Right to Information Act since it's an executive order, executive decision. So it is covered under Right to Information Act and people like Brinda Grover, Ashutosh can easily access to it, apply for RTI online and you'll get all the details available.
What is the
I
moral
think the
compulsion
government needs to
for
take
Desh
some
Ratan
onus,
to
stop putting
justify this?
responsibility for
I do not,
everything.
I'm really amazed
Let
today.
the government put
that
it out.
the
Let
Desh
the
Ratan
Union
is trying to
Home Ministry put it
justify
out. The Prime
unjustifiable.
Minister on
He could have
15th
easily
August
said
said
this is a
he
wrong
stands
done.
for respect for women. The Prime Minister needs to put it out. The
All
Prime
right.
Minister of
All
India
right, there
should
has to be
also
transparency
come from the
inside this
rampart.
entire
Ask
process.
the
This
Prime
is not an
Minister to
ordinary
put this
crime
information out.
by any means. There
It's
needs
not
to be
ours.
transparency. Why isn't the government A, talking, B, outing this report? What's there to hide? Look, I'm out of time on all of this. This has been one of the saddest attacks on any human being anywhere which has been reported or heard of. And today Bilkis Bano continues to suffer. I'd like to thank you for joining us on this debate, and let's hope there is transparency and let's hope there is justice. Well, earlier on I spoke to Yaqub Rasool, the husband of Bilkis Bano. When I spoke to him, he said that Bilkis was too shocked to really respond. बिल्किस को इतने सालों तक नरक झेलना पड़ा है और अब ये फैसला आ गया है. बिल्किस ने इस फैसले पे क्या कहा है?
इतने साल लड़ाई लड़ने के बाद आज जो फैसला जो 15 अगस्त को गुजरात सरकार ने जो आरोपियों को 11 को रिहा कर दिया, उस बारे में हम बहुत सदमे में हैं और हमको उसके बारे में कुछ भी मालूम नहीं था कि ये क्या हुआ है. जब लोकल मीडिया से पता चला हमको कि भाई आपके केस के आरोपियों को छोड़ दिया गया है, तो हम अचानक से एक चौंक गए और हमको पूरे घर में एक बहुत बड़ा शॉट लगा कि क्या हो गया.
2002 में जो हुआ था एक बंद चैप्टर था, एक बंद अध्याय था, जिसे अब फिर से बिल्किस के लिए, आपके लिए खोल दिया गया है.
ये हम अभी तो कहने का मतलब जो भी आज 11 आरोपी को जो छोड़ दिया गया है उसके बारे में जो हम आज जो इतनी बड़ी अदालत ने और बॉम्बे हाई कोर्ट तक उनका सजा का बरकरार रहना और सुप्रीम कोर्ट के उसके अंदर अभी तक का उनका कॉम्पिटिशन कब तक का चुकादा जो हमारे देश के संविधान ने हमको जो सपोर्ट किया था, और आज हम वो सोच रहे हैं कि एक ही झटके में हमारी 18 साल की लड़ाई खत्म हो चुकी है.
क्या अब आप इस कोर्ट में चुनौती देंगे?
देखो, इस वक्त हम बहुत सदमे में हैं. हम बिल्किस की बहुत मायूस है, किसी से अभी बात भी नहीं कर रही है और बहुत मुश्किल है. जो डर वो लोग आरोपी जब पैरोल पे छूट के आ रहे थे तो कम डर था, लेकिन आज वो पूरी तरह छूट गए हैं तो डर हमारे दिल में और हमको बहुत डर लग रहा है.
इन लोगों के रिहाई पर बिल्किस से सलाह नहीं ली गई. क्या आप मानते हैं कि ये बहुत गलत था?
बिल्कुल गलत. जो इनकी रिहाई की कोई सुनवाई, कुछ भी हमारे पास लीगल नोटिस स्टेट गवर्नमेंट ने या कुछ भी हमको बताया नहीं कि आप तो हमको कैसे पता चलेगा?
आपको सॉरी क्या बता रहे थे? उनको एकदम मतलब आपका कोई आइडिया नहीं था? बिल्किस को किसी ने
बिल्कुल कोई आइडिया नहीं था जब तक लास्ट मोमेंट में लोकल मीडिया से पता चला हमको कि आपके केस में 11 आरोपी को स्टेट गवर्नमेंट ने, गुजरात सरकार ने छोड़ दिया।
आप अपनी और बिल्किस की शारीरिक सुरक्षा को लेकर चिंतित है क्योंकि इन लोगों को रिहा कर दिया गया है?
बहुत चिंतित है हम लोग।
तो आप लोग क्या करेंगे? मतलब और कहीं जाना पड़ेगा आपको, और कहीं रहना पड़ेगा आपको? आप और कहीं जाना चाहेंगे? मतलब आप क्या करेंगे अब?
देखो अभी हम कोई चीज बता नहीं पा रहे हैं हमको क्या कहीं जाना है, क्या है करना है, क्योंकि हमारे पास ऐसे कोई लीगल कोई पेपर नहीं है और हमारे पास उसकी कोई सूचना नहीं है, अभी तक कोई जानकारी नहीं है। जब तक उनको जानकारी देने के हमको पता चलेगा तभी उसके में कुछ कर पाएंगे, लेकिन अभी हम बहुत दुखी है।
क्या आप मानते हैं कि ये बिल्किस को निशाना बनाने की एक राजनीतिक साजिश है?
मैं उसमें नहीं पढ़ना चाहता हूं, लेकिन हमारे साथ जो हुआ है और जो 11 बिल्किस के साथ जो हुआ है और 11 दोषी को स्टेट गवर्नमेंट ने छोड़ दिया है, वो हमारे साथ नाइंसाफी हुई है।
Bilkis Bano's lawyer Shobha Gupta fought this tooth and nail from pillar to post for so many years. Today, when the remission of these 11 people has been allowed, they're all convicts, not people. She is beyond words. She doesn't have any words. She is surprised at how this could have happened at all. And what does this really mean? Has Bilkis reacted to the release of these 11 men?
Yeah, she is in acute shock.
Are you going to challenge this, ma'am, legally?
Not yet decided what to do.
Does she want to challenge it legally? I mean, you are obviously
She has still to come to
but
terms to. She has still to come to terms to the, for her the battle was over with the last order of Supreme Court in 2019.
Yes.
When the compensation was granted, which was the highest ever compensation in a rape case in this country. So, and she was not learning to live her life peacefully. In fact, the judgment also noted, Justice Gogoi very precisely noted, the then Chief Justice, that she was, for all those 20 years running from one place to another place just for her safety. She had started to learn to live in peace without running from one place to another place, hide herself, look for her securities. And this has, I can't even tell you, Vishnu, in words like what she's into, what kind of thing the family is into right now. They don't know how to react. They don't know what to do. For last 2 days, Yaqub, her husband, was calling me and he said, ma'am, is there something Supreme Court has done? There are some rumors in the village. People are talking. There are tweets circulated. They are saying Supreme Court has granted them early release. I said, what are you talking? Nothing of that stuff happened and we have no news about it. We had to dig up everything only after getting to know, and it's a shocker. Believe you me, even I am not even been able to come to terms to yet.
Is it a shocker because on the one hand you've got the centre which in guidance to states has said that rape convicts shouldn't be given remission, and yet the state government goes ahead and does it anyway?
Yeah, why centre alone? Even the Supreme Court in their like n number of judgments, even constitutional bench judgments, the policy of remission has always been very clear. Remission, Supreme Court says in a latest constitutional bench judgment, it's not a matter of right. It is something, a benefit can be given when the accused pass out a test of certain factors to meet. Now, cases like this, we don't even expect a remission would be, asked for, and a court is, the government is granting, not even court. Here the government has granted them.
Ma'am, I'm just trying to...
And what does this matter? It's not a simple 302. It's not a simple, very, no rape case is simple. But it is gang rape for more than one person. A 302. The whole world has seen the fight of this lady for 20 years. Like, it is unbelievable. What are you talking? What are we into? What are we up to? Like, ask me, I have no words to even understand this. What are we up to now? A matter like this, bulk remission order. Just imagine the situation of this lady. She is living just door next door. 11 of the accused, one has died, otherwise they would have been 12. 11 of her rapists are out on road. Whenever they used to come out on parole, she would be in trauma. She would be fearing her safety. I'm not saying as if tomorrow they are going to kill her or do something to her. The fact is the fear factor.
What is she going to do about that fear factor? Are you going to, are you worried about her physical safety with these men being out? Are you going to shift location? Are you going to get more security for her?
Honestly, can't even say all that on a national TV. But the fact remains, none of us know what to do. Honestly, we don't have an answer. We are like whosoever was with Bilkis in all her journey. We have no clue what to do.
I thought it's important to speak to someone as distinguished as Justice Pradeep Nandajok, former Chief Justice of the Bombay High Court. Very privileged to have him with us. Thanks, sir, very much for being with us. Sir, the Gujarat government, in releasing these 11 accused, relied on a 1992 policy as opposed to a revised policy of 2014, which would have made them ineligible for remission. Is there a legal infirmity in this?
Well, it's like this. This issue has been a subject matter of a Supreme Court decision, which says that if there was a policy in vogue at the time when the offense was committed, and there is a subsequent policy, the one which is beneficial may be applied. Meaning thereby that if in 1992 we had a policy which was more stringent, and in 2014 it became liberal, then the 1992 could be applied, and vice versa. If the 2014 one became more liberal, then the 2014 one could have applied. So to that extent, I think the executive decision to apply the 1992 policy cannot be faulted. Mm-hmm. Having said that, having a power to do something is one thing, but whether that power has been rightly and correctly exercised is a different matter altogether.
Justice, what about the process of consultation? Was it not bound on the Gujarat government to inform the Supreme Court that we have a 2014 policy as well? And even prior to the Supreme Court considering that argument, shouldn't there have been a policy of consultation between the state and the centre, saying on the one hand it's the policy of the centre to disallow remission for rape cases, on the other hand there is this 1992 decision or judgment which was taken, a 1992 order, but we also follow a 2014 order in Gujarat. What do we do?
Well, it's like this. The issue of prisons is a state subject, and the policies which are issued by the central government are guidelines.
Right.
So ultimately, in the arena of law, the policy would be the one which the state has followed.
All right, Justice Nandajok, thank you very much for you're sharing your legal opinion on this, and of course also referring to how this bothers our collective conscience. It's such a horrific crime which someone had to go through. Thank you, sir.
Yes, it surely does. Thank you.
Thank you, sir.